All right, guys, today our thoughts on the Alan Coley email. Is it case closed here for the USCCA controversy? Maybe, maybe not. Stay tuned. This is attorney Andy Marcantel and attorney Mark J. Victor. We are the partners at the Attorneys for Freedom Law Firm. Ready to make a fun video today. How you doing today, Mark?
I am absolutely fantastic. I woke up this morning, as I try to do every day, and I think about the advice from the great Roman Emperor Marcus Aurelius. He says, when you wake in the morning, think about what a precious privilege it is to be alive. And that's exactly what I thought when I opened up my eyes this morning. I said, I'm alive. I'm above ground. It's going to be another awesome day. And yeah, just excited to be here, excited to be working with you, excited to be doing what we're doing.
You know, we've said on this show before that we're lawyers and everything and we talk law all day, but whenever we're not in the law firm and we're talking about other things, it's only like 1% law and 99% things like philosophy and things like that. I love talking stoicism with you. I love this subject in general, moral philosophy.
It's one of our favorite, and maybe like publicly speaking, our favorite topic, besides private things like that. But yeah, love talking about philosophy, love talking about freedom. I mean, we're the attorneys for freedom, not, for a reason. We love talking about freedom, thinking about what can we do to better improve the world, to better improve ourselves. So yeah. It's a great day, Andy. Thanks for asking.
I'm glad the day finds you well, my friend. It finds me well. And today we need to address an email that came out. This email, which came out, I think, last week on Tuesday, has been posted, I believe, by the USCCA, and it regards the Alan Coley case. So everybody who has been following this already knows the tale, but bottom line is this is the guy who was involved with the YouTube prankster shooting in the mall in Virginia. At that point, he was represented by a public defender despite being a USCCA member. There was maybe less than total transparency for various reasons. It's tough to tell exactly, but the bottom line is people started speculating about what's going on here. Why does this guy have a public defender despite the fact that he's covered by USCCA, right?
Yeah, and certainly we were among the speculators, and we don't apologize for that. I think from the beginning we remained open-minded. We don't know. I feel like I still don't know what happened. But, on the other hand, I think we should keep this thing in perspective as well. Whatever happened in the Alan Coley case, and who knows if we'll ever know exactly what happened in the Alan Coley case, it's not the be-all, end-all of things, right? I mean, the issue that we really talk about when we make these kind of videos is we do our best to try to be accurate and fair in terms of comparing and contrasting what Attorneys on Retainer is about, what other companies are about. In fact, this week we are going to be releasing my somewhat fiery critique of the Attorneys on Retainer program. I know people might be surprised to hear that. I've critiqued lots of other programs. I'm going to be critiquing the Attorneys on Retainer program, I think with the same fire, tearing apart the things we don't cover.
I haven't seen that video yet. They're still editing it right now?
I think it's almost ready.
Well, you better, Mark, you better be critiquing it with the same ferocity that you have all of our competitors' stuff, or I'm going to let you know.
I mean, look, to be fair, I'm in a little bit of a conflict position here, but I think I did a pretty good job.
I'll make a video critiquing your critique video if it's week T, my dude.
That'd be fantastic, man. But I think people will judge for themselves, but I think I did a very good job of tearing apart places where companies like USCCA are better than Attorneys on Retainer. I mean, there's some obvious things, right? They have vast training resources. USCCA covers a civil judgment, the liability, because, they deal with an insurance company, and that's a function of insurance. Attorneys on Retainer doesn't cover that.
I hear you get a tote bag as well.
That's right. We don't have tote bags, although we do now have T-shirts, which are actually
Why don't we
cool.
have tote bags?
I don't know.
This is this is a low transaction cost to catch up with the competitors.
We just got T-shirts, man. Let's be happy with those. They're actually really good T-shirts. I hope people check them out. So, look, in terms of the programs, we stand by Attorneys on Retainer. Our program, we think, is the best program out there. For starters, we don't exclude criminal acts. I mean, there's really no escape from that in terms of the insurance companies. They are very clear in terms of what they exclude, and we've got a good program. I mean, we list in our contract all the things that we do not exclude, and there's a pretty long list. People can check the Attorneys on Retainer contract out by just going to attorneysonretainer.us. Go to the FAQs up at top. There's a bunch of questions in there, but one of them is, how do I check out the contract? Look at the contract, read it. And by the way, if you sign up, you're going to get what I would call an excruciatingly long video. It's over an hour of me taking you through every single word of the attorneys on retainer agreement and explaining it in, layman's terms. It's really not that confusing, but I want to make sure that everybody understands everything. And at the end of that video, you check either yes, I understand, or no, I still got questions, and either me or you or one of our lawyers gets on the phone with them. We're doing our best to be transparent and letting people know exactly what it is we cover, what it is we don't.
Yeah, and something that you just said that I think would be really important, maybe we can throw the link down in the description, but our team assembled a handy-dandy kind of matrix chart that shows what other companies, what our competitors exclude for, what they can have the right to exclude coverage for, compared to what we do not exclude for. And I think it's pretty telling. People have found that pretty helpful in determining how the programs kind of stack up to one another, so I'd certainly encourage people to check that out.
Since we're talking about USCCA in this video, I think the first thing I would sort of try to refocus, and we're going to talk about COLI, right? We need to talk about the COLI issue. I think that's what primarily this video is about.
We've gotten a lot of comments. We need to respond to all those comments because we definitely have some thoughts, but I think it's important to kind of put it in perspective first, right?
Yeah, I mean, I think what that video that USCCA has released, in all of their videos, what they don't say is, here's what our contract is about. In fact, there are some things they say that, maybe arguably you might say, well, that's not what the contract says. So, maybe if we go really fast through some of their contract issues, and, as I say in so many videos, I just happen to have right here in my hand, this isn't actually the USCCA contract.
I feel like everywhere you go, there's just contracts hanging out everywhere in
I carry them around with
very
me.
Convenient reach.
I happen to carry around USCCA's self-defense liability coverage declaration. It's not actually the USCCA contract because USCCA has a deal with this company called Universal Fire and Casualty Insurance Company. That's what this is. This is the insurance policy that you get when you're a member of the USCCA and you want their self-defense liability coverage. Just a couple things real fast. And by the way, I downloaded this today from the USCCA website.
So that is the most current version.
Yeah, people can download it for themselves. Like, don't take my word for it. Look at it for yourself. We mention all the time, USCCA, they always talk about, hey, if you're charged with a crime, don't worry about it. We'll handle it. We'll represent you. And to some extent, they're right. But if that crime actually turns out to be a criminal act, I know there's a fine distinction, right, with the concept of being charged with a crime and having somebody at the insurance company say, you know what, it's actually a criminal act. We agree with the prosecutor. We agree with the grand jury. We've decided it's a criminal act. Okay, I'm not making this stuff up. If you look at page 2 of the insurance contract that USCCA provides, you'll see exclusions. And here's what it says. This policy does not apply to and provides no insurance for, Section B, criminal acts. Any criminal act by any insured. All right, so there's no speculating about that. If you're a member of USCCA or you're thinking about becoming a member and you're wondering about whether or not the insurance policy covers criminal acts, it doesn't. Okay, that's right in their contract. And by the way, it also doesn't explain some things that are important, right? Who decides if it's a criminal act? I mean, it doesn't tell you, is it someone at the insurance company? You would think, because it's an insurance policy, who is the person that decides? What's the criteria? And, where do they get the information from? Do they get the information maybe from the attorney who's representing you, who's required to follow their litigation guidelines?
Yeah, we've talked about this specific issue before and major ethics concerns that we believe it creates when an attorney is required by their contract with this insurance company to provide them with protected confidential information about their client's case, their client being the covered member, having to provide that information to a third-party insurance company that has the power, the unilateral power, to nix their coverage. Seems like a pretty tough conflict to me.
Yeah, and then there's this other situation. I mean, this email that, is now out there allegedly written by Mr. Alan Coley. Maybe it was. I don't know who wrote the thing. But it made clear that at least he believed he got to select his counsel. And this is said over and over again by members of the USCCA or people pitching for the USCCA. You get to select your own counsel. Look, I love Tom Grieve. He's a great guy. We've actually become very friendly over this whole thing. And I think he does a very classy video. I think he's probably a very good lawyer. I really enjoy talking to the guy.
Yeah, I remember you were talking to him. I walked into your office and you were on the phone with him. I think he told me that in my next video I need to take it easier on him or something. I don't think I said anything that crazy about it. I like Tom. I like Tom a lot. Shout out to Tom. I like his content. I think he's a good lawyer.
But he got this one wrong.
He really got this one wrong.
He got this one wrong. I want to say it as gently as possible. I don't want to put any words in his mouth, but here's what he said.
One of those benefits is the fact that they get to choose any criminal defense attorney they want. Unlimited coverage. Go ahead, pick the biggest, best person, man, woman, doesn't matter. Pick the best attorney you want. The USCCA will stick a check in their pocket. They are now your attorney.
All right, so that's what Tom said, right? But that's not exactly what the contract says. If you look at page 2 of the contract, and again, I'm going to read right from it. This is the insurance company, right? Universal Fire and Casualty Insurance Company, their self-defense liability coverage declarations. Here's what it says on page 2. This is section E from page 2. Quote, "We have the right to assign counsel of our choosing." Okay, and then it goes on. "We will not unreasonably withhold approval of defense counsel requested by the insured, provided that such counsel, in our sole judgment, has the necessary professional experience to defend the claim and, number 1, agrees to operate within our litigation and panel counsel guidelines, and number 2, agrees to our usual and customary rates and billing guidelines." End quote. This is pretty clear. You don't get to select your counsel. We have the right to assign counsel of our choosing. And you get to make recommendations, but whoever they pick, that counsel has to agree to operate within the litigation and panel counsel guidelines. I don't know what those guidelines are. What's required? Do you have to?
What are the customary hourly rates?
Yeah, that's the other thing. What are the usual and customary hourly rates that the insurance company is? Now, look, in my experience in 30 years of doing this, insurance companies don't generally pay top dollar for lawyers. They just don't. They extend contracts and lawyers generally, and I don't know about this company here, but they're not known for paying top dollars for lawyers. Okay, so I wanted to clear that up. You don't get to select the counsel of your choice. That's not what the contract says. And to Tom's credit, he has gotten this one right in the past. Remember, there was a previous video he did where he made it very clear that coverage ends upon conviction.
That's right.
Coverage stops in the event of a conviction.
And the reason why he says that, and the reason why no insurance company can say otherwise, is because there is a public policy in the United States that says you cannot provide insurance for an illegal act, period.
That's right. And so that's in there. But so, okay, to be fair, page 2 of the same contract we're looking at. Here's what it says. Section F, our obligation to perform under this policy to pay compensatory damages and our right and duty to defend the insured against a law enforcement inquiry or any claim seeking compensatory damages ends, and then section B, in the event of the insured's conviction of any criminal charge. Then it goes on and explains it has to arise out of the occurrence. So that's what the contract actually says. Now, if people want to buy the USCCA policy, if you think that that's better than the attorneys on retainer deal where we can represent you even if it's a criminal act, we have none of these exclusions, we're actually a law firm, we've been defending people who have actually committed criminal acts. I've been doing this for 30 years.
And who are actually guilty of criminal acts and who take plea deals that end with convictions, who get convicted and then we represent on appeal. It is not a hang-up for us. We are an actual law firm full of criminal defense attorneys. So that's the difference than dealing with an insurance company, for example.
Okay, a couple other quick things about the USCCA contract they don't often talk about. Page 4, subsection L, unlawful use or possession of a firearm is excluded. Use or possession of a firearm or other weapon in violation of 18 United States Code Section 922 or other applicable federal law, that's excluded. Sorry, no coverage for you under USCCA. Very last point, just quick point I wanted to make about USCCA's contract. They talk about, hey, we never asked for the money back.
The recoupment provision.
The recoupment provision. Yeah, you should know about this if you're a USCCA member. Check out page 8, subsection I. Here's what it says. Recovery or recoupment. Quote, we shall have the right to seek recovery or recoupment from an insured, the amount of any payments made to, for, or on behalf of the insured, including payments made to third parties, if it is determined that any such payments were made for matters not covered by this policy or are otherwise prohibited by applicable law, period. So they say they don't ask for it. If they don't ask for it, why is it in there? They have a right to seek recoupment. So if you're charged with a crime and they do decide it's not a criminal act and you wind up taking a plea, like lots of people do in the criminal justice system, you now got to worry about whether USCCA is going to exercise. And actually, let me say that differently. It's not USCCA. It's not Tim Schmidt.
It's the insurance company. That's right.
You got to worry about not Tim, and not Tom Grieve, and not any of the other good people over at USCCA, but somebody at that insurance company, whether that person is going to seek recovery or recoupment of everything that they paid. Like, that's what the contract says. Okay, so you can take issue with it if you want. They can say, well, it's never been exercised. I don't know if that's true or not, because sometimes, as we just showed.
Yeah, I think to be fair, I think Tom Grieve said in one of his videos he's not aware of it ever being exercised in all of his cases that he's done for USCCA. So
fair enough. Okay, so has it been exercised? Who knows?
And yeah, I'll also mention there, obviously, that if people want to see the entire breakdown, because we got a lot more to say about the USCCA contract, as well as, I mean, we're not just picking on USCCA here, obviously. If you know this channel, you know that we go through each one of these contracts because we think it's really important that people be armed with this knowledge and these companies be transparent. We're certainly trying to do that with videos like this. But Mark, if you're done complaining and critiquing about USCCA's
contract, to the fun stuff now.
Let's give the people what they want and talk about the Alan Coley email. What do you say, my friend?
Well, there's a lot of talk about we were driving a narrative and doing.
There's actually not a lot of talk about AOR specifically driving a narrative. I want to point this out first. This is kind of interesting to me, and I don't know what to make of it. USCCA and their representatives, such as Tom Grieve, have released videos where it's obvious that they're talking about our program, but we're not named, right? So there was a video that said, these attorneys selling retainers.
Right.
Or, something like phrased in a way where they just don't say the name. We'll say, hi, we'll say USCCA.
Yeah,
we use
the truth.
Names. We use the name. We're not trying to hide the ball or anything. We don't care if our critiques of this drive more eyes to there. They should. We should be looking at every single option in the market. So for whatever reason, they refused to name us, and in this most recent video Mr. Grieve released yesterday, he didn't name us. However, we got as close as we've ever had, Mark, to being named in one of the hashtags. He said like USCCA, blah, hashtag AOR. So I consider that a mention. Finally, they're mentioning our name. That must mean that we've made it.
I want to give Tom the benefit of the doubt here, right? I mean, look, Tom called me before he dropped the video.
He did,
and it was very classy and said, hey, Mark, just want to let you know I'm not trying to blow anybody up. I'm not trying to do anything in pride. And I believe him on that. I think Tom, at the end of the day, is a good guy.
Yeah, why wouldn't Tom, though, given that the position that Tom's in, I'm not sure what his arrangement is with USCCA, but what does he have to lose if he's analyzing everything on the marketplace? What does he have to lose by mentioning our product's name?
I think he's just.
Was he?
Let's give him the benefit of the doubt. He's trying to be classy.
You can give him the benefit of the doubt, but I suspect there might have been something that happened there.
So you're being tough on Tom again. There you go, man.
Well, I mean, he has no reason, given how friendly he's been to us in our correspondence, he has no reason to hide our program's name, and it makes me it's stuff like this, non-transparency, and people catch on to this stuff that makes people speculate and get suspicious and everything. That was he told by USCCA, you can't name these guys. We don't want to drive traffic to their program. We don't want people reading their contract. I don't know.
All right, so
I'm speculating.
To be fair. Here's what we said previously about the Alan Coley case.
The prosecutor filed something to ask the judge to allow the state to present evidence to the jury at trial that right after the shooting, Mr. Coley immediately made a phone call to the United States Concealed Carry Association.
From his speed dial, which he had programmed.
Speed dial.
Yeah, that's how we found out, and I think other people found out, that this guy, Mr. Coley, was a USCCA, or at least appears to have been a USCCA member, and he wound up with a public defender. How did that happen?
How did that happen?
I said, well, do you know why? You're on the case. He said, I don't really know about that. So what I did was I did some research. I wasn't familiar with the USCCA, so I looked on their website. I found out that they excluded criminal acts, and I figured this coverage was just for civil, and I think very reasonably, right? Because they say they exclude criminal acts, and he concluded that this is simply a matter for civil coverage and didn't think anything of it, didn't push it any further, and we moved on in our conversation.
Right.
If that's the case, and again, we don't know for sure. We're speculating. I mean, I know what Mr. Pouliard told me, but we haven't spoken with Mr. Coley. We haven't seen any contract with USCCA or anything like that. I mean, I could imagine maybe Mr. Coley wasn't paid up on his dues or something. Who knows? There could be some things.
Yeah,
like
if we're wrong on this, we're definitely going to come back
Yep.
and do right by USCCA and, finish the story, basically.
Yes.
But based on our conversation with Mr. Coley's lawyer, it appears to be the case that he was a USCCA member.
I hope people look at this very carefully, and especially people who are in these programs that sort of exclude bad shoots. They exclude, and it's got to be a lawful act of self-defense. This is an easy one to look at as one of those other companies, just like it appears USCCA did here, and say, oh, no, this is not a legitimate act of self-defense. We're not going to cover it. So I think we've been very clear from the beginning that we don't have all the information, and frankly, we still don't have all the information in this case. But one thing we learned from this video that we weren't 100% sure about before is Mr. Coley definitely was a USCCA member in good standing at the time of that incident. There is no question about that. And the question that's on everybody's mind, if you look at the video that Mr. Schmidt released to deal supposedly with this situation, Andy, what is the most common comment on Mr. Schmidt's video?
Quote, why was Alan Coley represented by a public defender if he had coverage, end quote. As of the day of this recording, that is definitely the highest rated comment, highest liked comment, highest commented on comment of people saying, yeah, what that guy asked.
And to be fair, we've remained open-minded. We still remain open-minded. We still don't know exactly what happened in that case. I think we got to be open-minded about everything. But it does raise a question to me. It makes me wonder if there's...
It raises a lot of questions.
I mean, all this speculation could have been ended by the USCCA right at the beginning. Why not come on? I mean, they dropped videos earlier. Tim Schmidt dropped a video. Tom Grieve dropped an earlier video talking about Alan Coley or trying to do what I'd call damage control. Why not just say, hey, everybody, we're in touch with Mr. Coley. We've been in touch with him from day one. He selected a public defender. That was his choice. He has a good one.
Yeah, and I see some apologists saying, well, it's because there was a pending case, and, he shouldn't be talking about a customer's pending case.
Yeah, let's clear that up right now.
Yeah, okay, so first of all, the claim that he can't talk about it is ridiculous because there is no attorney-client privilege going on here at all.
As Tom says in his video, there are no USCCA attorneys,
That's
right? And so USCCA easily could have come out and said he selected an attorney. By the way, there's no statement there. It doesn't affect the case. He has a public defender. I mean, it could raise a question, right? Because imagine, there's so many questions here, right? Alan Coley has to qualify for a public defender, and he has to be indigent for a public defender. Makes you wonder if this all is true, and I'm not saying it's not, but if this was the case from the beginning, how does Alan Coley represent to the judge or his public defender on his behalf if he knows, hey, I've been chosen under the USCCA and the insurance company's contract, I'm going to be the guy, I'm the lawyer. How does he represent to the judge, Mr. Coley's indigent?
Yeah, that's right. Let's talk about that for a minute. I mean, it's seen as a big deal when somebody needs the taxpayer to pay for their attorney. We want to put safeguards in there so that we can weed out people who actually aren't indigent. And so there's an inquiry. We see this all the time.
Right.
Right? There's an inquiry that happens at the beginning of the case to determine whether or not somebody's even eligible for a public defender in the first place.
Often under oath.
Often under oath and often in a sworn statement document that you have to submit to the
I don't
court.
have any money, any means to hire.
Any means to hire.
I
any
cannot.
resources.
I have no way to get a lawyer, and so therefore the public needs to pay for one for me. How does he say that if it's actually true that at the beginning of the case, USCCA offered not just a lawyer, but all of the benefits that come along with that, which is the expert witness, the investigator. By the way, where were those fees? Did the USCCA pay for an investigator for Mr. Coley? Did they pay for an expert witness? I bet that might have been helpful on the case to have a use of force expert who could maybe have taken the stand to talk about, all the various things. There were 3 people there, right? Not just you see 2, but there's somebody in the other video, and how things could have changed very quickly and how a substantial risk of serious physical injury could have been present. I mean, why not bring in a use of force expert?
No question. If we had a case like this, we would have at least a couple experts on the case, probably use of force expert, very, very common in these, to talk about different legal standards of what constitutes self-defense, what a threat is, and what you're legally justified to do, escalation of force, proportionate force. These are tough points to explain to the jury, and so this is why attorneys oftentimes bring in experts. And USCCA advertises that they are building you a full dream team. They got your back, everything like that.
Where was the rest of the team?
Where was the experts? Where were the investigators? I don't know. Did he waive those things?
When did the USCCA? I mean, we know Mr. Coley reached out right away, right? He called speed dial. I know this, and I remember I spoke to his public defender early on.
We'll talk about that in a second. But let's stay at the beginning of the.
Yeah, so he reaches out right away. When did somebody from the USCCA reach back and say, hey, Mr. Coley, we got your back? Do you need experts? Do you need investigators? Because if you look at the court document, the public defender isn't even appointed for over 30 days.
That's right.
After the arrest.
Do you have the paperwork there? Let's get the dates absolutely correct.
All right, I think I have him written down. He's arrested on April 2nd, 2023, and the public defender is officially appointed on May 4th, 2023.
So over 30 days later.
Over 30 days later. So it makes you wonder what happened in those first 30 days. Where was the USCCA attorney? Because if Mr. Pouliard isn't even appointed, hard to imagine that Mr. Coley would have actually selected Mr. Pouliard. If he wasn't even appointed, he probably didn't even meet the guy. How do you meet the guy before he's even appointed to the case?
So in other words, I mean, assuming that's what they're claiming happened, then he's sitting in jail for 30 days saying, nope, I do not want to take the lawyer that I have paid for, that I bought coverage for. You guys keep him. I want a, as of right now, unknown, unnamed public defender that they'll appoint to me eventually. Keep the coverage that you're willing to give me that I paid for, and I'll just wait for a public defender. 30 days later, public defender gets appointed, and then he says, I choose him, and I waive my coverage to apparently not only to have a private attorney appointed to my case, but the experts, investigators, all those other knickknacks. No worries, I'll go with the public defender.
And where's the form, by the way? I mean, imagine an insurance company, real insurance company, right? This is Universal Fire and Casualty Insurance Company. They say, yep, we're on the hook to pay benefits. And the person, the insured now, is declining the benefits. What, they're just going to take a phone call or something? They're not going to send, okay, here's your waiver of benefits form. Sign the form. Why would they do that? Because they don't want to be sued later. What if Mr. Coley right now came out and said, you know what? The insurance company was obligated to provide benefits to me and they never did. Where's the proof that he declined? Maybe there is a waiver of rights form, right? I'm waiving my benefits. I'm signing here. So the insurance company has it in their file. But if there is, why wasn't that produced? That seems like the obvious document to have produced.
Yeah, like the analogy here that I think is helpful for people to wrap their minds about why these types of waivers are important in standard procedure is imagining that you got your car insured and you got into an accident and then you went in to collect the insurance that you were paid for and you sat down with your insurance agent and they said, all right, you're totally covered. Here's your check to buy a new car. And then you tell them, you know what, despite paying for the insurance and despite the fact that you're offering me a giant check right now to take care of the car, I'm good. I decline it. I'm good. You're good. And so if there's not a waiver form, then we're being asked to believe that the insurance company just said, okay, sounds good. We'll just make a verbal agreement here. No reason to, muddy any of this up with legally binding paperwork or anything.
Right.
Have a nice day, and you walk out of the insurance company. Like, it's not realistic. I doubt that's the case.
Nothing in this very carefully scripted email says that the USCCA ever offered him an attorney. Schmidt didn't say that. Tom Grieve didn't say that. It says in the email, with the USCCA, I can have the attorney of my choice, which, by the way, isn't necessarily true, as we just covered.
Right.
I know I could have requested that the USCCA pay for a private criminal defense attorney for my case. It didn't say. The USCCA contacted me immediately, just like they said they would, and they offered to provide a privately paid or an insurance company paid criminal defense attorney for me, and then I declined it. Interesting.
There's lots and lots and lots of questions that this whole thing generates.
When did they first talk to Mr. Coley?
And when did he first talk to his public defender?
Right.
I mean, like, I could imagine a scenario where the public defender comes and visits him in custody, but isn't officially appointed to the court. Maybe he really loves that first visit he has before it's appointed. But just in most jurisdictions, it doesn't shake out that way. You don't actually meet your public defender until they are appointed. And so while it's possible the public defender, even though not appointed at that point, could have came and talked to him in that month after his arrest before he was appointed, it's just not something that we see often.
You and I pulled up the email that I had with the public defender, Mr. Pouliard, and although I didn't bring it in here, it was dated early November.
November 8th.
And it referenced a conversation I had with him on the phone in October. Seems very interesting that he never even mentioned, and we specifically talked about USCCA, he doesn't even mention, oh yeah, USCCA offered my client a private defense attorney, but instead he opted to have me represent him.
That's what I was saying. It's like, do you know who didn't know that Mr. Coley willingly chose his public defender over a private lawyer? His public defender.
Right.
We spoke to him in October, which was a number of months after his arrest and after his appointment on the case. He had no idea what the point of USCCA even is, because we asked him about it. We said, hey, so we understand we were looking at the pleadings in the case, and it looks like the prosecutor over this last summer of 2023 filed something to try to get the judge to allow the state to introduce the fact that Mr. Coley had called USCCA shortly after the emergency, which is a really interesting subject that doesn't exist with a law firm, for example, because of the attorney-client privilege. And I think that's worth talking about in a minute, but I digress. He said, I thought USCCA was some sort of civil coverage, civil liability coverage, and I had no idea it even applied to criminal law or charges. In fact, I looked at the contract, and it said doesn't apply to criminal cases, so I just kind of ignored it and move on. This was our conversation with Mr. Coley's lawyer, Mr. Pouliard, in October 2023.
Seems awful strange, right? If you buy the sort of narrative that the USCCA is now wanting everybody to believe.
They had his back the whole time.
The whole time.
That's 6 months into the case right there, and his lawyer didn't even know what USCCA was for, didn't know that his client had allegedly waived the criminal private attorney for him, did research himself, couldn't figure it out, and certainly doesn't appear from our conversations with him, since he didn't even know, the purpose of USCCA. I think we can infer from that. They never reached out to him to say, hey, by the way, do you need help? I see you're representing one of our clients, one of our customers, and, we're going to provide you with an expert and the resources that you need, whatever you need, investigator, everything like that. We have our clients' backs, or I should say our customers or our insured's backs. And so what resources can we provide you, sir?
I mean, if Mr. Pouliard knew that USCCA was available and then he allowed his client to represent to the court that he was indigent, I mean, that's a problem, right? That's a false statement to the court. And we lawyers, and all lawyers know this, you got an obligation to first get the client to fix it. And if the client doesn't fix it, you got to fix it.
That's right.
You can't let your client just offer a false statement to the court. And to
be clear, I don't believe that happened.
I don't think that happened either.
All.
No,
I don't believe that happened at all. I'm inclined to give the benefit of the doubt to Mr. Pouliard because he sounded very genuine. He sounded like a good lawyer from our conversation. He's clearly a good lawyer.
Right,
He won the case.
Either Mr. Pouliard knew that his client was making a false statement to the court about being indigent, or he didn't. If he didn't, then he knows nothing about the USCCA or any of these things. It's sort of pretty good evidence of what's going on in Attorney Pouliard's mind. I'll also say this, which is I just think strange, right? And people can make their own judgments about this. You know, I had a couple of phone calls with the guy. We exchanged emails. It was really very enthused.
Very cordial, yeah.
Very cordial.
Yeah, I spoke to him as well. Yeah, we both spoke to him. Yeah.
He was very cordial and happy about coming in and maybe doing a video with us. I think I had even mentioned it in one of the videos. The email says, yeah, as soon as the case is over. The guy doesn't even return my calls now. I've called him several times. I've sent several emails to him. Not even a response. And I know he's in the office. That's just very strange conduct. Now, I don't know what to make of that. You could imagine a sinister purpose there, but you could also imagine, I don't know, maybe he's busy, maybe he's in trial.
Maybe he's inundated with stuff from people about the case. Once again, I'm inclined to give him the benefit of the doubt on this, but it is very strange that he spoke to us, returned our calls and emails and everything like that back in October, November, but then when this whole thing started really blowing up, with the Alan Coley thing, and people started talking and sharing the information around, and USCCA was obviously suffering some bad PR. We haven't gotten any responses since, so it's odd. I hope he still calls us, by the way. I hope he reaches out today.
Yeah, I mean, we'd love to get to the bottom of what happened here. We just want to find out what happened. There's a lot of questions here, and things just, for me, are not adding up. Tom also mentioned in his video that he thought the USCCA posted bond. You know, I don't know this for sure either, but I don't think that that's what happened here either. I guess I'll defer to Tom because, you know, he should know this, right? I mean, he's pitching for USCCA and he's putting a video out and he mentions that the USCCA, he thinks, posted the bond. But that's not what I understand happened here. I think bond was denied, and then after sentencing, he got released. There wasn't a bond posted. So if that's the case, USCCA, who allegedly in the insurance company had his back the whole time, did nothing. He picked a public defender. It seems he didn't get an investigator. He didn't get an expert witness. He didn't get any support of any kind. Certainly doesn't seem at least consistent with what USCCA, or at least the narrative, right? We had his back the whole time. We've been in constant contact with the guy. We're doing everything we can. Sounds a lot more like damage control to me.
Right. And another thing that I want to point out is that when you have all of these types of inconsistencies going on, because USCCA right now is complaining about all the rampant speculation, and they're complaining about don't be too quick to judgment, and we're completely exonerated because of this email and blah, 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 blah. They created this controversy.
That's right.
They created this, and they're still not being completely transparent about all of these things as far as I'm concerned. I want the answer to these questions, but in the very least, you can't get upset when you do all of these suspicious things to many people and then get upset when they ask questions or speculate and say, we can't talk about it. Rest assured, we're right and we didn't act with any wrongdoing. But for an unexplained reason, we're not going to talk about it. And a quick one more thing to say about that, Mark. Anybody who says, we've already demonstrated why anybody who says they can't talk about it is wrong. There's no attorney-client privilege. But other apologists for USCCA said, well, they're just trying to protect his privacy, and they're just trying to protect, be respectful of one of their clients. BS. They were talking about the existence of him as a client while everything was still pending. They were talking about these things. They were making statements. They were making ominous, vague statements, however, and so the type of things that would get people talking and speculating. Yeah,
and they had no problem talking about Kayla Giles, right? Another one.
No problem.
Another one who they dropped, and then Tim Schmidt really kind of hung her out to dry in his video, put a whole bunch of facts out there. I don't know where he got those facts. Again, I don't know if it's true or not. Look, the extent of our knowledge on Kayla Giles is that we actually spoke to her criminal defense lawyer, who was paid $50,000 by the USCCA's insurance company, and he thought it was an arguable case of self-defense. In fact, it was stronger than that. He thought it was a good case.
He told us he thought it was an excellent case of self-defense, and he would have been excited to take it to a jury. That's what he told us.
And they certainly didn't have any problems hanging her out to dry and putting a whole bunch of really maybe controversial but very inflammatory facts out there. Who knows if she would have been convicted if she had had the full resources that USCCA promises, right? A proper expert, investigators, a full team on that case. I don't know if she would have been convicted or not. I don't know. And look, I don't want to get into a thing about the facts, because in every case that's charged, somebody thinks the evidence is pretty strong for conviction, right? That's the prosecutors don't charge cases that they don't think that they got a reasonable likelihood of conviction.
If they think it's likely that it's going to get dismissed, and by charging it, they're simply just squandering state resources, then they're not going to bring the case.
Right. In every case charged, you would think there's a lawyer who thinks that there's good evidence in the case for not self-defense, but for a criminal act. So that's the case on everyone. Said another way, insurance company could decide in every case, yep, we agree with the prosecutor. Yep, we agree with the grand jury. It's a criminal act.
Right.
We're denying coverage.
Yeah, obviously,
but let's talk about this email.
Okay, let's talk about the email. I think we should read it, okay? A lot of people have concerns about this email. We may have some too. Here we go. It's on January 23rd, 2024. What else happened that day, Mark? Oh, yeah. It was the first day of SHOT Show. I'm sure a total coincidence that this hit the public at a massive gathering of the Second Amendment community. Okay, let's read the email. Mr. Coley sent the following email to Tim Schmidt. Dear Tim, I want to address criticism that the USCCA has received about me and the attorney I chose for my case. You want to talk about this line by line? Let's break it down like that.
Criticism of Alan Coley in the attorney he chose. I didn't see one piece of criticism on Alan Coley. I mean, other than some people say I didn't agree with what he did. I think it's a bad shoot.
May have been a bad shoot.
Yeah. But people weren't criticizing him or the attorney he chose on the case. That's awfully strange. The criticism was all about the USCCA, and the question was, why does he have a public defender? I don't know how many comments I saw in videos in response to Tim's damage control video saying, Tim, you didn't answer the one thing we want to know. Why did he have a public defender? Would have been pretty easy at that time to just say,
He chose one.
He chose one.
He chose one.
That's it.
He chose one. That's it.
Yeah. But instead of saying that, maybe that narrative didn't exist at the time. I don't know.
The response instead was, we still do represent him. We did not disclaim liability.
Right. We're covering
but I'm not going to tell
his appeal.
We're going to cover his appeal. We'll talk about that in a minute, because I'm pretty sure a man named Tom Grieve once told me that in the incident of a conviction, all coverage ends, but we'll get to that in a minute.
Except for cases where you're doing damage control.
No crap. But anyway, that was the response. It's like, we can't tell you what's going on and everything like that. It made a lot of people suspicious. But anyway, back to the letter.
But just think about that. You're going to say all of those things about the case, and you're not going to add the one thing that everybody wanted to know that was all over the comments. Why did he have a public defender? He chose one.
Yeah. How would it be disrespectful for his client in any way, shape, or form to simply say, and we respected his choice to choose the attorney of his choosing. That's why he has it. It doesn't make sense. So even if that's true, the conduct here, they should be expecting people to speculate, and they shouldn't be complaining about it. It's a controversy of their own creation. All right, continuing on. I am a member in good standing with the USCCA and continue to be. So he's informing Tim Schmidt right now.
The president of the company.
Who is in the midst of a PR firestorm.
Right, just letting you know.
He's informing the guy that he is a member in good standing with the USCCA.
I'm sure Tim got that and said, whew, good. I was wondering. I didn't know if the guy was a member in good standing or not.
Okay. With the USCCA, I can have the attorney of my choice.
Yeah, not exactly. Tom says in his...
Oops, Mr. Coley didn't read the contract.
Yeah, he didn't read the contract. And to be fair with Tom said it was low resolution explanation of that. It was really, really low resolution.
All right, continuing on. I know I could have requested that the USCCA pay for a private practice criminal defense attorney for my case. I chose Attorney Pouliard because he is a great attorney who believed in me and believed in my case. Yes, he's a public defender, and he fought for me and won. So, once again, hearkening back to our questions, when did he first meet Mr. Pouliard? Was it during that 30-plus day period between when he was arrested and put into a cage and when the public defender's office was actually appointed?
Yeah, did he have a USCCA paid lawyer or insurance company paid lawyer there at that release hearing trying to argue for his release, or was he hung out to dry? Be nice to know the answer to those questions.
Yeah, and USCCA could, of course, release answers to these questions at any time because they have no attorney-client privilege here. And obviously, you can tell from this, he loves USCCA and everything like that, wants to help him out. That's the whole reason he's writing this letter, right? So you really think he'd be disrespected if they explained answers to these basic questions? Anyway, back to the letter. I am glad that I have the choice and wouldn't change anything about my representation. The USCCA stood by me and continues to stand by me, and I thank them for that. Sincerely, Alan Coley, USCCA member. And then there's some stuff at the bottom in the USCCA's framing of this where they're essentially taking a victory lap and saying, all right, that's the close of the case. Now everybody make sure not to speculate in the future and just eat the narrative that we feed.
You know, sometimes
that's my own rephrasing.
Right.
I may have been a little bit.
You know, sometimes clients will say, when I say, look, man, you got to write a letter to the judge for sentencing, right? They say, Mark, will you just write it for me? And I say no. And you know why I say no? Because it comes out sounding like this. That's why.
Yeah.
That's why.
I always tell clients that. I said, I don't want your statement to sound like it's written by a lawyer. I want that judge to say, oh, okay, this is from you. I want the prosecutor, if I'm getting like character letters for a client that I'm sending to a prosecutor, no, I'm not going to help you with the letter. Here's basically what you need, but it needs to be in your voice.
Yeah. Now,
and this is exactly what we're trying to avoid.
It's conceivably possible that Mr. Coley thought he needed to send this email to Tim Schmidt to inform him of these kinds of things, and this is what he wrote from his heart. It's possible, but it just seems so ridiculous that that's actually what happened here. When you read it and you listen to the language and you see how it's signed USCCA member, it sure seems more likely that
it's like a perfectly crafted PR recovery email.
I wonder if he got paid for that. I mean, I certainly have no reason to think
that's
the case.
That's the speculation right now.
I'm speculating.
Everybody's saying, how much money did they pay him to write this? And if that's the case, Alan, if you're listening, we'll pay you more to hear the real story. Get in touch with us, man.
It'd be nice to know the real story. But, you know, I don't know. We have obviously no reason to think, but we don't know what happened here. It would be nice to know. That would make a lot of sense to me, right? If USCCA was in damage control mode and they found Alan Coley, because, of course, they got his name in their systems there, and they called him up and said, hey, man, I know you're upset. I know we didn't do things right, but we want to make it right. Here's $50,000. We need you to send an email. We'll write it for you. Just send it to Tim. Here's his email address. Send it over so we can release this statement and make a, say we've had his back the whole time. He chose the public defender. I don't know that happened.
Yeah, there is no evidence that I've seen that indicates that they paid him off in any way, shape, or form. That's a big allegation, right? We're
not even making that allegation. We're saying that would make more sense here, right?
Yeah.
I'm not even posing it as an allegation. That would fit the narrative that is appearing to everybody, I think, better.
Yeah, it's one of the things that people are proposing as an explanation for all of this strange stuff. There's just lots and lots of strange stuff. And we don't know what happened, and all the people speculating in the 2A community don't know what happened, and perhaps none of us will ever know what happened, but suffice it to say, a lot of people's questions weren't fully answered by this
or answered
letter.
At all.
A lot of people are not of the mindset of, oh, okay, this is all I needed to see. USCCA did no wrong whatsoever.
Everything's great.
I'm comfortable with them. Case closed.
Move
and
on.
I will not hear any argument. I mean, blah, 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 blah. Like, I'm totally, yay, rah, 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 USC. That's not the majority of the 2A
No, it's not.
Right?
No. And under the category of weird stuff, looking at the court docket.
Yeah, okay, I know.
And
we're not done.
We're not done looking at the court docket here, because I think we're going to wind up getting the entire record from the Coley case and just seeing if we can get to the bottom.
We have been told by the court staff in Virginia that the entire file is on the way. I don't know whether that's true. I don't know if there's going to be redacted things.
I think it's coming.
But I am on the edge of my seat. I can't wait.
From looking at the docket, that the USCCA was served a subpoena. And it was served on August 30, 2023. And there was a hearing on September 13, 2023. When I look at the docket for September 13, 2023, it only shows one particular motion, and it says it was granted. I don't know what it was. Be interesting to try to find out what that was. There was nothing in any of these statements about that.
Yeah, this was shortly after that hullabaloo where the prosecutor attempted to get it into evidence, basically, to present to the jury that he called USCCA. This is interesting.
You were going to mention something about
that. Yeah, and we took a little detour because we were on a different thing. But I think this is worth mentioning.
It is worth mentioning.
The fact that the prosecutor filed a motion basically trying to show consciousness of guilt, we assume, because he called the USCCA. Oh, go ahead.
Or maybe they just want to know what was said.
Right?
Because as I've said on many occasions,
attorney-client privilege,
if you call the USCCA and you're talking to somebody, they're not a law firm. And if they say what happened and you say this happened, this happened,
I shot him and I screwed up and I ran. I think I killed the guy. I messed up big time. Something like that. All discoverable. You're not talking to a lawyer.
And if you think that the prosecutor is not going to go after that statement, this case shows otherwise.
That's right. But also, prosecutors are allowed to do something called consciousness of guilt. They're allowed to say, well, his conduct, I want to present his conduct to the jury to have the jury make an inference to find that he was acting as if he was guilty. And I don't know if that was the purpose of it here. But the point is this, and it's a very important point to keep in mind. That motion was denied, the one that the prosecutor filed to try to get that in front of the jury. But it was not denied on its merits. In other words, the judge never actually got and sat down and looked at the case law and made a determination based on the rules of evidence. Rather, the prosecutor kind of screwed up in this case and filed it untimely, filed it late.
That's why it was denied. So we don't know where it would have gone. But imagine how things may have gone differently here, right? Imagine the prosecutor moves for this information earlier in the case and the judge grants it. And maybe they do a deposition of the people that they spoke to over at the USCCA. Again, I've said it on many occasions about, the dangers of you were just involved in some kind of a shooting. Maybe you're getting arrested or just got arrested or about to be arrested or something. And then you call someone that's not a lawyer. And anything you say, and that someone includes the people at the USCCA. They're not lawyers. You heard Tom said in his video, there are no USCCA lawyers. So when you call the USCCA, you're talking to someone. It may as well be a recorded line because everything that has been said, that prosecutor, if they find out about it, will very likely subpoena that person, depose that person, put that person on the stand at your trial. Do you really want to take that risk? That's why, if you're dealing with a criminal offense, you want to talk to a criminal defense lawyer. At the end of the day, this is why we believe AOR is the better product here for all these reasons.
I think there's one more thing worth saying to keep in mind, which is that regardless of how Coley gets to the finish line in this case, I hope he wins. I hope he wins his appeal. I'm happy with his conduct. And we did a full legal analysis of the Alan Coley shooting video, which was a really fun video to make and had a lot of really interesting legal points. That's some of our favorite stuff to do, is actual legal analysis of a shooting.
We're lawyers. We like to do the lawyering.
So maybe we'll throw that video down in the description so you guys click on that, check that out if you want to see what our opinions are of the actual shoot. We've been asked to address this controversy, but I hope that he wins his appeal. Whoever represents him.
He should.
Remember, there's a whole firestorm here, but in the middle of it all is a human being, and I hope that he ends up winning his appeal, regardless of who pays for it.
Yeah, and your point was good in this, and I don't want it to be lost. We heard from our good friend Tom Grieve that all coverage ends upon conviction. Well, he was convicted. The thing that is on appeal right now is something he was convicted of at trial.
He was criminally convicted.
And the USCCA now, in contravention of their own video and in their own contract, which I showed earlier, is now spending money to do the appeal. So maybe they should amend the contract and say, unless it's a high-profile case and we're doing damage control, if all coverage ends. I don't know, but it just seems odd. There's a lot of things that seem very strange here. Again, we're not making stuff up. Do your own research. I read from the contract. You can find out and confirm and corroborate the things that we're saying on your own.
All right, Mark, so I think a good way to close this is revealing something that you and I just decided to do right before we walked into this room, essentially.
Yeah, we either leave it here, and we have all these questions that we're speculating
rampant
about.
Speculation.
We don't know what happened. We've raised a bunch of questions in this. There are things that USCCA could come out and just simply say, here's what happened. They could, every question we raised in this video, they could just simply answer.
Easily.
Yeah, if they wanted to.
Yeah.
And so we decided why not do what we normally do in these situations? Just ask the questions. So I'm going to write a letter to Tim Schmidt, and it's going to be very friendly and very nice and civilized and all that. But I'm going to lay out and say, look, here are the things that we're wondering about. We would like to clear it up. And send it over there. And I got no power to make them answer these questions. There's no court proceeding pending where we get the right of discovery, where we could force them to answer questions and dig into things. None of that's going on. No. And so I'm just writing a friendly letter to say, look, here are the questions we have. And when I say we, I think there's a lot of people out there who are interested in answers to these questions.
We know there are.
We know there are. I'm going to write a letter to Tim on behalf of us and everybody else and say, here are the questions. And by the way, if people watching this video right now, if you got some question you want me to ask Tim Schmidt, put it in the comments. And if it's something we think's a good question, it's not already on the list of stuff.
Let's make a letter together with the community and let's send that over. That's a great idea, Mark.
Let's send it over to Tim and ask our questions. They're not gotcha questions. They're questions that we talked about here, the kind of things we'd like to know, like what happened in this case.
And make them civil and respectful questions, not like how do you sleep at night or anything like that, but stuff that you want to know, that you were confused about or speculating about the Alan Coley case or anything else.
Yeah, and to be fair, I don't ask people to do things that I wouldn't do myself, and so I will invite him. If he has questions or things he's confused about in terms of the AOR program, write questions back to me, and I'll be happy to answer. I'll also offer, if you want to come on our podcast.
Come on the podcast.
Yeah,
please.
If you want to do a live thing, we can sit down. And in fact,
I've actually wanted to do a podcast with Tom Grieve for a while now because, like I mentioned, I think he's a good lawyer. I like his legal analysis, and I think the three of us could chop it up pretty well on a video critique or looking at, critiquing somebody's acts of self-defense. I think that'd be a fun video to make.
But let's compare and contrast our different programs, right? You ask me questions, I'll ask you questions. And look, if Tim doesn't want to come, that's fine. You can send Tom Grieve. You can send someone else from USCCA or whoever the decision maker is at the insurance company, maybe is the person to address these questions to. If they want to come together and all four of us can talk, we can do it recorded. We could do it live.
Let's do it live. That's my favorite.
I like live too, but that's fine. However they want to do it's fine. We are the point.
Hey, can you put in the clip of Bill O'Reilly yelling, "Let's do it live"?
We'll do it live.
Yeah, and let's get to the bottom. Let's have a friendly discussion comparing and contrasting our different programs. And look, like I've said it, like where we started with this thing, there are things about USCCA that are better than the AOR program. If you like those things, sign up in the USCCA. There's lots of people, by the way, who sign up in both because we get questions all the time. I love AOR, but there are other programs. Can you do both programs? Yeah, that's fine. We don't have any problem with that. Our position is the more information, accurate information that gets out to the market about our program and all of the other programs, the better. And we don't have to get everybody joining AOR. If it's the other programs are better for you, sign up in the other programs. If you like AOR, sign up in AOR. If you want both, sign up in both. If you want to ignore the whole thing, hope you don't get into a problem, and then later on you can hire us or any other criminal defense lawyer you want if you need one. You could do that too. Most people do that.
I'm going to start with a more modest goal than getting them to appear on our podcast and have a transparent conversation about all these things. I'd just like USCCA to mention our name on one of their videos. I mean, that to me is like we've made it. Like, obviously they're threatened by our program and they don't want to send any eyeballs over to read our stuff. Like, to me, I don't know why they won't just say attorneys on retainer.
How interesting that Tom made the point in his video about a lot of people made a lot of money. Nobody's making more money than USCCA here.
800,000 members, right?
And nobody's making more money than USCCA here. And I tend to think Tom's not doing these videos for free either.
But hold up, there's another issue that I take with that, which is why the shame about making money? Why on earth the shame about making money? Any money that we've made as a result of AOR, I am proud of. I honestly believe that we have the best product in the industry for all the reasons that we stated and more. And I am proud of every dime that we make. So I don't treat it as a capitalist. I don't treat it who worked hard on this program for years, incorporating the feedback of our listeners and modifying the program over and over, giving people what they wanted. Now we're seeing success by simply comparing ourselves to other programs. And, a lot of people made a lot of money off of the speculation. It's like, give me a break.
Right. We're free market capitalists. As long as you're proud of every dime that you make and as long as you use it in conformity with good character. I'll end with a Marcus Aurelius kind of a thought,
we're right back to where we started.
Right back to where we started. As long as you use those things in conformity with good character, there's no problem.
Very stoic, my brother.
Yep.
Remember, guys, the whole point of this is that we want people to do their own research. Read the contracts. Read our contract. Read all of the contracts of the competitors. As we say, and as we're about to talk about in depth too in our own critique, you better give us a really good scathing critique, Mark, and make sure to highlight the advantages of the other programs because they exist.
Yeah.
They exist. There are definitely reasons why you may want to have a different program, combined coverage, things like that. We believe we've made the best program on the market, but it's not about what we think. It's about what you believe. You should get what you feel most comfortable with for you and your family in the case that you have to act in self-defense. So all we're trying to do here is get people to do their own research, read the contracts, and make the decision for yourself. That's it. If you enjoyed the video today and you want to learn more about this program, go and check out attorneysonretainer.us. Learn all about this awesome program that we've created. Also, make sure and go to attorneysforfreedom.com to learn more about our law firm and what we're up to, the principles that we stand for, some high-profile cases we've worked on, meet the team, and all that good stuff as well. All right, my friends, this has been Attorney Andy Marcantel and Attorney Mark J. Victor. Once again, leave us your comments. If you think you got something wrong, we'd love to engage with you guys. You're the reason why we have such a successful program, so definitely leave us some comments down below, or if you wanted us to consider any questions that you have for our letter that we're planning to send to Mr. Schmidt over at USCCA. Also, if you enjoyed this video, we are asking that you share it. We think it's so important that the more information gets out to the Second Amendment community, the better. So please share this video, like it, subscribe to our channel, share it with a friend, and until next time, my friends, this has been Attorney Andy Marcantel and Attorney Mark J. Victor. Peace.